all parties, including the applicant, have participated in those by-elections. There has been no complaint by any of those parties on the performance of the first interested party. My Lord, it's critical to note that during that period, 2014 and 2017, the third interested parties candidate, the President of the Republic of Kenya, was still the President. And there's been no complaints. The first time, my Lord, that this issue has arisen is after this contract has been awarded to the first applicant, for the first interested party, for the supply of these election materials. And the question, my Lord, that we want to ask is this. If there is no complaint regarding the performance of the first interested party in circumstances where it has delivered, and there's been satisfaction by all parties that have participated in those by-elections, is there a basis for the respondent to have said it will exclude the first interested party from participating? And the question, my Lord, must be in the negative. And so, my Lord, the other thing that I need to just point out is that there seems to be a misunderstanding of the method of procurement called direct procurement. My Lord, direct procurement, just like any of the other procurement methods, involves evaluation. So it is not like you call someone and you give him a contract. It involves evaluation. So there is a tender that is prepared. There is invitation of bid, but although you only deal with one person, then that bid is evaluated, negotiations are held, and due diligence is carried out. At that point, my Lord, there is no comparison between two suppliers. You are dealing with only one supplier. And so, my Lord, the suggestion that the applicant, the respondent ought to have considered another supplier doesn't arise. You choose one supplier and you deal with that one supplier, provided they meet the criteria for the supply of the goods required. And so, my Lord, once the respondent had selected to deal with the first respondent or the first interested party, it went through the provisions of Section 104 and it complied with the procedure set out there. And so, my Lord, the respondent, therefore, cannot be faulted for not having complied with the provisions of statute. Now, my Lord, two quick points in conclusion. First of all, my Lord, at the earliest, the applicant was aware of the decision to proceed by way of direct procurement at the latest, on the 24th of May 2017. My Lord, it was aware of the decision to proceed with the first interested party at the latest on the 9th of June 2017. It did not file this application until the 22nd of June 2017. My Lord, that's dilatory conduct. A party that sits on its rights up to that stage cannot then come to the court and seek an order reversing what has already happened during the period when it was sitting on its rights. And so, my lords, the conduct of the applicant in this case, my lord, does not give confidence that it genuinely came to court because it felt aggrieved. The second issue, my lord, that I want to comment about, my lord, is throughout the submissions by counsel for the applicant, I've waited for them to say what prejudice, how they will be prejudiced if the respondent proceeds, or rather the printing of the ballot boxes proceeds through the first interested party. That would have been the critical issue There is no mention. There is an allegation that there is a possibility of ballot stuffing. That's the only issue, my lord, that has been alluded to. But we have said, my lord, that we invited the applicant and other stakeholders to visit the printing press to ensure that they are satisfied with the manner in which the printing is being undertaken and the security of the ballot boxes. My lord will notice when you retire to write your judgment, Ezra Chiloba has also set out the security features embedded in the ballot papers.
Those are live proceedings from Milimani Law Courts here in Nairobi. That case touching on the ballot